Well, good evening and welcome to AJ 101 Criminal Law Online. And tonight we are going to be discussing Chapter 5, Parties to Crimes. And before we get going, just a quick reminder about those resources that are located at the end of your textbook, the student review, where there's the terminology and definitions, the true or false quiz, the essay questions, and then the matching terminology quiz. Continue to do those exercises and use those to help you study for your weekly quizzes and also your chapter exams. So let's go ahead and jump right into parties to crime, and we're going to start off with talking about what we call principles of shared liability. Now, not only those who actually commit a crime, but also those who assist in its commission or help the suspects evade justice are in fact criminally liable. So for example, if a person who commits a robbery is aided by a getaway driver and is subsequently hidden from law enforcement by, say, friends or relatives, all of these parties are criminally accountable for their acts. Now, we're going to talk about aiders and abettors and accessories later on, but aiders and abettors are those, such as the getaway driver, who helped that suspect commit the crime. Accessories are those like friends or relatives who hide the criminal to assist that suspect after the crime in order to help him or her avoid detection or apprehension. Now, all of them can be punished under the law. So just kind of a quick review here. The actual suspect of a crime is not just the only one who assumes some type of criminal liability. Those who aid the suspect before, during, and after the crime, as we just heard, can be held criminally culpable, and along with those who harbor and conceal that individual in order to help them avoid apprehension or arrest can also be liable as well. So when we go into this thing called principles, we're going to first look at the definition of what a principle is. So under Penal Code 31, all persons concerned in the commission of the crime, felony, or misdemeanor who directly commit the act, aid and abet in its commission, not being present but advise or encourage, counsel, advise, encourage anyone under 14, advise those who are mentally incapacitated, use any type of fraud or contrivance, or use any types of threat or coercion are in fact considered principles. Now, earlier in law, we had degrees of principles and something called like accessory before and after the fact. So this penal code that you're looking at here falls under something that are called distinctions nullified, and Penal Code 971 basically eliminates the old common law distinctions of these two following terms. So principle in the first degree and principle in the second degree, and then accessory before the fact, meaning before the act may have happened, or accessory after the fact, meaning after it happened. We now simplified this, and we only have two terms. We have Penal Code 31 that defines what a principle is, and we just kind of went over that. And we have Penal Code 32 that talks about what an accessory is, and we'll talk about that a little bit later on in tonight's discussion. So, excuse me, when we talk about elements of offense and principles together, as noted in Penal Code 31, all persons involved in any way in the planning, preparation, or carrying out of any crime become principles. Now, this is even true. Think about this. It's kind of interesting. It's even true if they're not present at the time the crime is committed. So that's kind of an interesting thing when you look at law, and that's why it's good to go back and go through your textbook and look at some of these different definitions. Now, the key elements for that, when you're talking about, if they are not present, would be aids and abets in the commission of a crime, advises and encourages its commission even if they're not present, fraudulently gets another person drunk for the purpose of causing that person to commit a crime, or compelling another to commit a crime by threats, menace, or even coercion. Now, the first sentence of Penal Code 31, which reads, all persons concerned in the commission of a crime, whether it be a felony or misdemeanor, means that designation principle really does apply to all crimes, misdemeanors, infractions, and felonies. And that next portion of the sentence, where it says whether they directly commit the act or aid and abet in its commission, we're going to talk a little bit more as we kind of go down the road in our lecture. But keep in mind, and there's a little side note here, that aiders and abettors and accessories may actually be tried and convicted even if the actual suspect is not. So let's say the getaway driver and the suspect that goes in to rob the store, they both get caught, and there's maybe a search and seizure or an ID issue or whatever it is that comes up that might somehow get that the main person that went in to do the robbery might get them off. That really doesn't have any impact on the person that was the accessory or the aider and abettor. They can actually be tried and convicted even if that main suspect, the guy with the gun, if you will, went in and committed the crime. So again, interesting type of situation here. In addition to Penal Code 31 principle defined and Penal Code 32 accessory defined, there are several other sections of the California Penal Code which will really help give us a clearer picture of who parties to crimes are and the various acts which can make them such. And these are listed here. We're not going to go through all of these, but these are some other sections of California Penal Code, those laws defining parties to a crime. And I'll let you take the time to go through some of these and familiarize yourself with those as well. But let's move on now to kind of a bigger piece, if you will, and talk a little bit about aiding and abetting and what it is. So we know what that principle is. So an aider and abettor is one who does not actually perpetrate the crime, but assists in the commission of the criminal offense. And remember, we just learned that persons may be found guilty of aiding and abetting only if they can be shown to have these different factors down here. So one would be have knowledge of the unlawful purpose, 2, share the same criminal intent as the actual suspect or the perpetrator, and 3, act, advise, supply, etc., which could equal assist in some way. So there's a case that goes with it, People versus Beeman. You don't really need to look it up, but it is kind of an interesting fact when you look at what an aider and abettor is as it compared to principle. So kind of a quick review here. A person aids and abets the commission of a crime if, with knowledge of the unlawful purpose of the suspect of the crime, he or she promotes, encourages, assists, or instigates by act or advice the commission of such crime. And we just kind of went over the things that need to be present in order for that to take place. Now, I mentioned that case, the Beeman case, and it talks about here People versus Beeman. And in that particular case, the Supreme Court ruled that persons may be found guilty of aiding and abetting a crime only if it can be shown that they share that same criminal intent as the suspect. And this doesn't mean that the aider and abettor must necessarily intend to participate personally, only that he or she knowingly support the suspect's intent and purpose. So if the mens rea, okay, or the mind, remember we talked about mens rea, of the aider and abettor is more culpable than the actual suspect, the aider and abettor may be guilty of a more serious crime than the actual suspect themselves. So kind of an interesting thing. Now if you're following along in your book, before we move on to kind of the next little piece, I want to take a really quick look at a case study, and it talks about responsibility of aider and abetting. So it's on page 63. So a striking example of the responsibility of one who aids and abets is contained in this case, People versus Hopkins. Now, in this case, an individual, Richard Hopkins, delivered a friend, Herbert Caro, who was quite ill, to the Park Emergency Hospital in San Francisco. Now, Caro was diagnosed as having narcotic poisoning, and Hopkins informed the doctor in attendance that Caro had taken heroin earlier that day. Now, Caro died that afternoon. Hopkins made a statement to the inspector of the San Francisco Police Department identifying himself as a merchant sailor. He stated that he had left his ship in San Francisco in early afternoon and visited a tavern in Marin County where he met Caro, whom he had known for about 3 years. He said the decedent, Caro, asked him if they would basically like to get high, to which he agreed. They left in Hopkins' car. Hopkins gave Caro $13, and Caro left. About 15 minutes later, he returned to the car having purchased some heroin. So you see that they're both, looks like they're going to do some heroin. They then drove out to a street called Funston Avenue, where they stopped. They opened the package, and Caro produced an eyedropper, which he filled with water at a service station. They drove around a few blocks, parked on 14th Avenue, where they took a cap of heroin and heated and mixed it with a spoon. After they mixed it, Hopkins said he took a shot in the arm, and then Caro took a shot. Hopkins wrapped a handkerchief around Caro's arm to force his veins out. And I think that's typical, right? If you can't get a vein, you're going to, wrap something around your arm to make the blood flow a little bit more prevalent in one area versus a different area, so you can see the vein. Now, Hopkins took another shot and then assisted Caro in taking his second shot in the same manner by wrapping the handkerchief around his arm as he had when he took the first shot. So after Caro took the second shot, he told Hopkins he felt sick. They got out of the car, or he got out of the car, attempted to vomit. He wasn't able to do it. Hopkins got out, walked around the car to Caro, who was by then practically unconscious. So Hopkins placed Caro in the back seat of the car, took him to the hospital emergency room. Now, when the decedent injected the heroin in his own arm, he violated a couple of different health and safety code sections. But when Hopkins manipulated the handkerchief or the tourniquet around the decedent's arm, he assisted him in the commission of an unlawful act, not amounting to a felony. As a result of these acts, the decedent died. Now, this is kind of an interesting case. In reviewing the case, the District Court of Appeal said this, okay? The help which Hopkins gave decedent brings him within the provisions of Section 31 of the Penal Code, principle defined, that he aided is clear, that he abetted is clear, since he and the decedent set out together with the purpose of doing that which section, which was 11.721 of the Health and Safety Code, basically stated. In order to charge Hopkins with manslaughter, it was not necessary for testimony before the grand jury to show that he injected heroin, since Section 31 draws no line between persons who directly commit the act constituting the offense and those who aid and abet in its commission. So again, just kind of, I know that seems like a little bit of legalese to you, but you can look how you can use some of these sections and how you could end up maybe being a principal an aider and abetter, and we'll talk about some other different things as we kind of go down the line. Now, the part about not being present when we look at Penal Code 31, the District Court of Appeal in the case of People versus Lewis, and this is another kind of interesting case, said to be a principle, it is not necessary that the person be present at the commission of the crime. And I'm going to let you take your time to kind of look at a couple of case studies that are on page 64 that talk about whether or not being present had anything to do with some of these different cases. So before we get into the criminal street gang section, I wanted to hit on a couple other areas that are listed under Penal Code 31. So we talked about the responsibility of aider and abetter, and we talked about not being present, encouraging children to commit crimes. Again, going back to Penal Code 31, we read all persons counseling, advising, or encouraging children under the age of 14 years to commit any crime. This part of Penal Code 31 defines a situation where the person who commits the act, such as a child under the age of 14, may not be guilty of any crime, yet the person who counseled, advised, or encouraged them to perform the prohibited act would be subject to prosecution as a principal. Use of fraud or force. Again, looking at Penal Code 31, we read in part, all persons who by fraud, contrivance, or force occasion the drunkenness of another for the purpose of causing him or her to commit a crime. Okay, examples would include causing a person to become intoxicated by means of fraud, contrivance, or force for the purpose of causing that person to participate in an act, let's say, of maybe sexual perversion, or to illegally use controlled substances, or to cause that person to commit theft, robbery, or burglary. What about use of threats? Well, under Penal Code 31, it reads in part, or who by threats, menaces, command, or coercion compels another to commit any crime are principals in any crime so committed. So it's possible the actual suspect of the offense under these circumstances, unless the offense be punishable by death, would have a defense under Penal Code 26. So, you have to kind of read these and look at these little pieces to make some of these laws kind of make sense. So now let's kind of keep going here and talk about another interesting element related to criminal street gangs. Now, all gang members who knowingly promote, further, or assist in felonious activity by the gang are guilty of a felony. Punishment may range from 16 months to life in prison, depending upon the crime and the circumstances. Now, that's Penal Code Section 186.22. After conviction or having a juvenile court petition sustained, gang members also must register with the sheriff or the police chief as a gang member for a period of 5 years, and failing to register within 10 days of release or change of address is a misdemeanor. And if a new felony is committed while that person is in violation of the registration requirement, an additional imprisonment of up to 3 years can apply. So here's another thing where we kind of talk about principles as well. So what about a co-principal then? So we've kind of beat up principal, and we kind of know what that is. But what about a co-principal? Well, all parties who are legally principals under the law are equally guilty, and we know that. So, for example, a person who serves as a lookout for a burglary or robbery is as guilty of the offense as his comrades, if you will, who entered and completed the crime. Now, further, all parties to the crime are responsible for the natural, reasonable, and probable consequences of the acts of any one of the others during the commission of a crime, and there's a case that goes with that. So co-principals are equally guilty. And again, so kind of review, this means a lookout can get the same amount of prison time as the actual suspect, because the law says all parties to crimes are responsible for their natural, reasonable, and probable consequences. Now, there is an exception here, and the exception is called the non-triggerman principle. And this is where the U.S. Supreme Court struck down the death penalty for non-triggermen, not a non-trigger man, criminals who did not intend to take part in the killing, but whose crime resulted in death. And basically the court is saying that the punishment here must be tailored to the personal responsibility. So on July 2nd of 1982, the United States Supreme Court basically struck down the death penalty for the non-triggerman criminal who did not intend to take part in a killing, but whose crimes resulted in death. So that ruling basically still stands today. That sharply divided court ruled that the imposition of death under such circumstances, as I just stated, violates the Constitution's ban on what we would call cruel and unusual punishment. And again, that ruling still stands today. So we've done the co-principal, we've done the principal, we've talked about aiding and abetting. Well, now let's move into this whole thing about accessory. So what's an accessory? Well, Penal Code 32 describes an accessory as one who aids a principal to avoid apprehension. And there are some requirements that are there. So after a felony, not for misdemeanors, so this is one where it's only applicable to a felony. So after a felony, one who harbors, conceals, or aids a principal in such felony with the intent that that principal may avoid escape from arrest, trial, conviction, or punishment, having knowledge that that said principal has committed such a felony or has been charged with such a felony or convicted thereof, is an accessory to that felony. Now, knowledge, again, is required. You have to know, and rumors are not enough. And we talked about, I just kind of mentioned, it talks about harboring that criminal or concealing them. So harbor means to furnish shelter, lodging, food. Conceal means to hide. And mere silence is not enough. So if you know where somebody might be, but you're not saying anything, that's a little bit different. You aren't actively concealing, you're just not saying anything. So mere silence is not enough to put you in this category of accessory. So the crime of being an accessory is punishable as a felony, but it is a wobbler, so it actually could be a misdemeanor if required. Now, in your textbook, it gives you a little bit more information as to each piece here as an accessory. So, for example, after felony committed. So note the language used in the section which reads, every person who after a felony has been committed. PC 32 applies only to felonies, okay, to make it clear, and only after they have been committed. That crime has been committed. There's no such thing as an accessory to a misdemeanor. Knowledge required. So note that PC 32 requires the accessory to have knowledge that that principal, okay, that suspect, has either committed a felony or has been charged with or convicted of a felony. Mere rumors is not enough. Harboring, we talked about that. To harbor a person means to receive that person secretly or covertly without lawful authority for the purpose of concealment. Concealing, define that word conceal as used in PC 32 means more than simple withholding of knowledge possessed by a party that a felony has been committed. The concealment necessary to constitute a crime includes some type of act upon the part of the person doing the concealing. And, so that kind of hopefully wraps up or gives you a better idea of the accessory defined. So we've gone through the principal, the aider and abetter. We've talked about the criminal street gang liability, the co-principal being equally guilty, and the responsibility issue relating to aiding and abetting and not being present and all those other pieces. Well, now let's look at kind of one of the last pieces, basically, would be what we call an accomplice. Now, Penal Code 1111 states that one who is liable to prosecution for the identical offense charged against the defendant on trial in the cause in which the testimony of the accomplice is given. To be an accomplice, the person must have aided or assisted in the offense with knowledge of the unlawful purpose. An accomplice is, in effect, a principal to the crime. Now, one interesting thing about an accomplice is a conviction cannot be had upon the testimony of an accomplice without some kind of corroboration. And basically what they're saying is if two people go in to rob the bank, the conviction cannot be had if just one person says, yeah, well, the other guy did it. You're going to need some other type of corroborating evidence in order to make that conviction stand, not just the word of one accomplice, if you will, or principal testifying against another accomplice or principal, if that kind of makes any sense. So corroboration required in that Penal Code 111, a little more definitive. We know a conviction cannot be held or had upon the testimony of an accomplice unless it be corroborated by such other evidence as shall tend to connect the defendant with the commission of the offense, and the corroboration is not sufficient if it merely shows the commission of the offense or the circumstance thereof. So there needs to be some independent corroborating evidence that tends to connect the defendant with the commission of the offense. And then finally, we're going to wrap it all up with what we call a feigned accomplice. And again, I know there's a lot of different terms, and this is, again, a good time to remind you of those resources that are in the back of your, at the end of each chapter, that help you talk about these different types of terms. Now, a feigned accomplice is one who participates in a crime for evidence gathering and prosecution purposes. And this type of accomplice fundamentally lacks that criminal intent. They are assisting for justice purposes. And an example of that could be an undercover police officer who's working under the direction of law enforcement, or an informant that is feeding information to law enforcement. That would be an example of a feigned accomplice. So kind of to review this, a feigned accomplice is one who participates in a crime for evidence gathering and prosecution purposes. A feigned accomplice, therefore, lacks criminal intent. The feigned accomplice's testimony need not be corroborated because he or she is not a true accomplice. So again, such person may be working under the direction of law enforcement, of a law enforcement officer, or upon his or her own initiative. As such, there is no criminal intent on the part of a feigned accomplice. So that's going to kind of wrap up, or it is going to wrap up Chapter 5. And again, if you have any questions regarding the chapter, please feel free to post them on the discussion board. And if you don't want to post them there, you can email me. And don't forget to take a look at those resources that are at the end of your Chapter 5 text in the book, including the terminology, the true-false quiz, the essay questions, and then also the matching terminology quiz. So with that being said, that will be it for tonight, and I'll talk to you soon.